Hi, this is Professor Unmack, and this narrated PowerPoint is about pure speech. So the First Amendment says Congress shall make no law infringing on the freedom of speech. And over time, the meaning of the word speech has expanded beyond just words coming out of your mouth. It also encompasses, as the First Amendment says, the right to not only speak your mind, but also to publish your ideas and thoughts. And so we also have a right to freedom of the press. But we're going to focus on pure speech today in this PowerPoint. And in the next PowerPoint, we'll talk about symbolic speech, which is expressing an idea without using words. But we're going to talk about pure speech right now. The first thing I want to talk a little bit about is why we place such a high value on free speech in pretty much any democratic type of system of government. Places a high value on free speech. And of course, we enshrine the right of free speech in the US Constitution, and that protects even speech that the majority doesn't want to hear. Right? You don't need a First Amendment to protect speech that doesn't bother anybody. But when somebody says something that makes the majority's blood boil or causes people to have their feelings hurt or things that they closely believe in challenged, that causes problems. And sometimes when the majority gets power, they might have a tendency to want to stop people from saying things that they don't want to hear. So the First Amendment is designed to protect not against what the majority likes, but what the minority wants. It protects those who society might want to shut up. So we have identified over time a lot of reasons free speech is valuable. If you think about it for a few minutes, you probably would come up with a list fairly similar to this. The first is the discovery of truth. And political scientists, political philosophers, other philosophers have talked about this for a long time. Lots of different thinkers have talked about the importance of free speech for the discovery of truth. The idea here is that when we allow the free and open exchange of ideas, the truth will eventually, it might take a long time, but eventually the arc of history will bend toward the truth winning out. So it's a hope, it's an aspiration, but the idea is that if you stifle discussion of things you don't believe, you run the risk that you will pass up an opportunity to become better educated, to find out you were wrong, and as a society, find out that we were wrong. So the discovery of truth is one of the reasons we value free speech. Obviously, free speech, freedom of the press, all of these things facilitate our participation in the political decision-making process. So without the ability to post things on Facebook or take out an ad or publish an editorial or for citizens to speak with one another about political matters and challenge candidates who are running for office, we wouldn't be able to participate in political decision making. So it's important for us, if we want to make wise decisions, if we want to participate knowledgeably in the political decision-making process, that we have access to information, that we have access to a wide range of information so that we can decide what positions we want to lobby for or what candidates we want to vote for, etc. Free speech is also super important for checking abuse of governmental power. Now, you can imagine that once a group of people gets power, they don't really like to have their exercise of power challenged. But one of the things that James Madison pointed out in the Federalist Papers way back in 1787 is that you can't always count on good people getting elected to office. As much as we want to rely on democratic principles of voting and choosing our leaders and not having leadership forced upon us in some sort of authoritarian or dictatorship or something like that, we have to recognize that people in power sometimes abuse their power. And without the ability to investigate potential wrongdoing by government, without the ability to gather information, to talk to people, to find sources, we wouldn't be able to uncover and check the abuse of government power. So if you think of all the gates that have happened in American history recently, Watergate and Iran Gate and all of the other gates that have happened, it's been the press in particular who have uncovered wrongdoing. And so if you think about even the recent impeachment process, regardless of which side you were on, that came about in part because people are entitled to have access to information about what's going on in government, and people are entitled to testify and to speak out. Sorry, my dog is barking. The dangers of narrated PowerPoints. And so checking abuse of government power and then fixing things. You can't really do that without being able to talk about things that you think the government is doing that are wrong. The other reason free speech is really important, and this is pretty widely accepted, is that if you don't give people the opportunity to express themselves, to vent their anger, to march in the streets, to agitate for change, you end up potentially having a lot of violence. If you don't give people an opportunity to try to change the system from within, if you try to stifle their debate, if you try to shut them up, if you try to censor them, especially if the government tries to censor people, those ideas don't go away. People need a safety valve. They need to be able to vent. They need to be able to try to get political leaders to listen to what they have to say. And that creates stability. We're going through a period in time right now where things are a little bit maybe unstable, and people are debating whether or not protests are peaceful or whether protests are spilling over into violence. But the notion that people have a right to organize, to march, to express their opinions, to challenge the status quo, that's something that's largely viewed as a positive thing. Obviously, we're not talking about burning down buildings and that kind of thing for the most part, but being able to express your anger, being able to try to persuade other people that the things that you care about are things that they should care about, especially the government, and especially during times of civil unrest and certainly in election years. We want people to feel that they have even if they don't win, they have an opportunity to continue to fight for what they are hoping to achieve. Free speech is also important for individual self-fulfillment. It allows people to express themselves, create an identity, in the process maybe find kindred spirits or other people who share the same ideas or the same loves or the same things that they find important, maybe the same religious beliefs or the same political beliefs, or even just things that people like to do for fun. Freedom of speech is an important part of recognizing that every individual is entitled to dignity and to pursue their, within the law, to pursue their dreams and to pursue the things that make them happy and that make them feel fulfilled. And there's a role in communication and free and open communication in helping that happen. Some people argue that free speech, especially the practice of extending protection to speech that we find hateful or personally upsetting, opens up lines of communication where we can explain to other people why their language is hurtful or hateful or personally offensive. And that opens dialogue. Instead of shutting down free speech, the idea is that if you allow the free and open exchange of ideas, you create a more tolerant society. It can be sometimes hard to believe that when you read some of the things that are put on social media, when you read some of the things that are said in our public dialogues, but it's hard to imagine changing people's minds or opening people up to listening to new ideas if you don't allow the free and open exchange of ideas. And what we'll find through this discussion of free speech is that the United States doesn't really allow very much interference with that. So we tolerate a lot of things in the United States that other countries don't tolerate, and in particular hate speech, which is protected by the First Amendment. It's not in other countries, and we have a lot of debate in this country about whether or not we have extended the right of free speech beyond what it should cover. There's a big debate about whether or not we should punish people for engaging in hate speech in particular. But at this point, we don't allow punishment of hate speech. The last thing that I would mention is that speech and the press, being able to publish whatever books people want to publish, or whatever blog posts, or whatever Facebook posts, or whatever you want to put on Instagram or whatever, creates a more robust and interesting community. Now, we're having a lot of debate in this country about whether or not private companies like Facebook and Instagram and Snapchat and Twitter, whether they should be required to extend the right of free speech in the same way that the government does. So when we talk about under what conditions can somebody's speech be punished, we're talking about under what conditions can the government punish somebody's speech. Private organizations, private companies like Facebook, etc., they're not necessarily covered by the First Amendment in the same way that the government would be. And so Facebook can ban certain groups from using Facebook as a platform, or moderate what is allowed to be placed on Twitter, or put warnings on certain tweets that the information contained in the tweet might be misleading or something like that. So mostly what we're talking about here in this class, and we can certainly extend our discussion beyond the government, but what we're really talking about is under what conditions can the government impose some sort of punishment on speech. And so that's what I want to talk about a little bit. So the concept of free speech and the protection of free speech has shifted and changed and morphed over time. In the beginning part of our history, there were some early attempts to punish people for seditious speech, and in the early part of our history. But the sort of modern day debate about how far your right of free speech extends really started in a case in 1919 called Schenck versus the United States. And Schenck is an important case because it established the first clear sort of test for the government, for the court to apply when the government punished somebody for their speech. In other words, when does it violate the First Amendment to punish somebody's speech, and when does it not? And that test was called the clear and present danger test. And it's still kind of talked about as the clear and present danger test, but it doesn't mean quite what it meant in 1919. So Schenck was an anti-war protester during the First World War, and he handed out a bunch of flyers encouraging men to refuse to allow themselves to be drafted. Schenck basically argued that the draft was a form of slavery, which was prohibited under the 13th Amendment to the Constitution, but His actions got him arrested. He was arrested and convicted of violating a law called the Sedition Act, which was established just a year before that, which made it a crime to interfere with the war effort. And so Schenck was arrested and convicted for trying to interfere with the war effort by keeping people from getting drafted. It didn't matter to the government that nobody really paid very much attention to Schenck, and it doesn't appear that anybody really tried to get out of the draft because of what Schenck said. But nevertheless, the court upheld his conviction, and they created what was called the clear and present danger test. And it was it gave the government a lot of power, the early clear and present danger test, because it allowed the government to punish speech that could have a bad effect, even if there was no likelihood that the bad effect would happen. It's sometimes referred to as the bad tendency test. So think about how much power that gives the government, where they can punish somebody for saying something or publishing something, even if the outcome of that isn't dangerous, right? So somebody just advocating an idea or expressing an idea or saying, I think we should become a communist country, even if there's very little or no likelihood that that is going to result in something that the government would want to avoid, the early application of the clear and present danger test allowed for people's speech to be punished just for advocating what the government considered to be dangerous ideas. They usually revolved around overthrowing capitalism or establishing a communist government. A lot of that in our country. And the classic example of this is a case from 1925, a really important case called Gitlow versus the United States. So this case is important for two reasons. One, it involved freedom of speech in a state rather than an infringement on freedom of speech by the federal government. And Gitlow is the case that incorporates the First Amendment free speech provisions to the states. So Gitlow is the case where the court said the First Amendment protects people from unconstitutional infringement of their speech at the state level as well as the federal level. But they said that in this case, the state of New York didn't actually violate his constitutional rights. So they extended the protection of the First Amendment to state action, but they upheld his conviction anyway. And what Gitlow argued at his trial, he was convicted under a criminal anarchy law, which punished advocating the overthrow of the government by force, even if there was no attempt to organize people to overthrow the government by force. The law punished people who advocated that. Gitlow argued at trial that since there was no resulting action flowing from what he published, the state was actually penalizing speech that didn't create a clear and present danger. New York argued that it was enough that the possibility was there that somebody might take what Gitlow wrote and use it to try to overthrow the government. So again, allowing the government to punish people just for advocating ideas that the government found dangerous, even if there was no likelihood that anybody would be incited to violence as a result of what they said. And so they upheld the clear and present danger test, but one of the justices on the court, Oliver Wendell Holmes, had a very sort of modern take on the clear and present danger test, and he wrote a dissent in this case, arguing that the clear and present danger test was being misused, that it really should only be used in clear cases of a potential danger flowing from the actual words that somebody had said or published. And this is what Holmes had to say. This was not the majority view on the court, but as you'll see, over time it becomes the majority view on the court. He says, every idea is an incitement. it offers itself for belief, and if believed, it is acted on, unless some other belief outweighs it or some failure of energy stifles the movement at its birth. The only difference between the expression of an opinion and an incitement in the narrower sense is the speaker's enthusiasm for the result. So Holmes was suggesting that under the court's interpretation of the clear and present danger test, anything could be published. If there was a possibility that some crazy person would listen to this speech and then engage in some violent activity, you could stifle the speech. You could punish the speaker, even though the speaker wasn't engaging in incitement. So that was the sort of early clear and present danger test. Another case came before the court that allowed a dissenting opinion to try to push the court toward the more modern stand that we have now. That was a case called Whitney versus California, and it involved the same kind of issue. Somebody belonged to an organization that advocated the revolutionary change. They advocated using force for revolutionary change. And in this case, it's a justice by the name of Louis Brandeis who parts with the majority and advocates for a free marketplace of ideas, which is closer to the standard that we have now. But again, this was not the standard adopted by the court. But one of the things that Brandeis says in this opinion has always stuck with me. He says, to courageous and self-reliant men with confidence in the power of free and fearless reasoning applied through the process of popular government, no danger flowing from speech can be deemed clear and present, unless the incidence of evil apprehended is so imminent that it may befall before there is an opportunity for full discussion. If there be time to expose through discussion the falsehoods and fallacies, to avert the evil by the processes of education, the remedy to be applied is more speech and not enforced silence. So that was in 1927, but that was not the majority on the court. So if we fast forward a little bit, we can see a shift on the court toward a new standard. So after World War I was over, and then after World War II was over, the big threat to America was seen to be communism. There was a lot of fear that communists had infiltrated the government, that they were secretly plotting to overthrow the government, and Congress reacted by passing a couple of laws that were designed to deal with the issue of communism. The Smith Act, which was passed in 1940, made it a crime to advocate or belong to any group that advocated the forceful overthrow of the government. The McCarran Act required members of the Communist Party to register with the U.S. Attorney General's office. And all of these things led to what were known as the McCarthy hearings. There was a senator named Joe McCarthy who was a rabid sort of anti-communist, and as a result, Congress held a bunch of hearings where suspected communists were forced to testify, and they tried to get them to rat out their friends and that kind of stuff. It's generally considered sort of a black mark on American history in terms of allowing people the free and open expression of ideas. The Smith Act was upheld in 1950 in a case called Dennis versus the United States. But in this case, the court started to make a distinction between the advocacy of dangerous ideas and the mere teaching of communist philosophy. So the court said, if there's evidence that somebody is not just explaining what communism is or distributing information about how you could learn about communism, but was actually advocating that communism be installed, then they could still be punished. But the court starts to make this sort of distinction between the abstract expression of an idea, which they wanted to protect, and trying to move a little bit more toward allowing the government only to punish speech that is intending to accomplish what somebody is advocating. And in 1957, the court draws a much clearer distinction between advocacy as an abstract principle and advocacy of concrete action. So here we see from 1950 to 1957, the court kind of shifts. Dennis gave the government continued to give the government a lot of leeway, although the court is starting to recognize that just reading the Communist Manifesto shouldn't get somebody, put in prison, or a political philosophy teacher having students read the Communist Manifesto and discuss the ideas in there isn't the same as trying to mobilize that group of students to forcefully overthrow the government. In Yates versus the United States in 1957, the court draws a much clearer distinction. And they say, you know what, actually advocating the violent overthrow of the government as an abstract principle, talking about the pluses and minuses, is different from advocating concrete action. And so now the court says you can't really punish somebody for arguing that communism should be implemented. You could still punish somebody for trying to get people to take steps, to take concrete steps to arm themselves, or to march on the government and try and take over. And the court says in 1957, he says, the Smith Act does not prohibit advocacy and teaching of forcible overthrow of the government as an abstract principle divorced from any effort to instigate action to that end. So that's a big distinction. And the court also drew a distinction between the advocacy and teaching of forcible overthrow as an abstract principle and the advocacy and teaching of concrete action for the forcible overthrow of the government. And the court recognized that instances of speech that amounted to advocacy of action were few and far between. So in 1957, the court's kind of taken baby steps toward protecting more speech than certainly the clear and present danger test allowed. It wasn't until we get to 1969 that the court establishes the current standard. And this is a case called Brandenburg versus Ohio. I've asked you to watch a whole video about Brandenburg versus Ohio. Brandenburg was a Ku Klux Klan leader. This is a very scary, picture of Klansmen doing their Klan things. And Clarence Brandenburg was a Ku Klux Klan leader in Ohio, and he made a speech where he invited the press to come to his speech, and essentially what he said was that the Klan was sort of fed up with civil rights. They were fed up with efforts to improve the lot of African Americans, to increase people's rights to vote, and essentially said, we are going to stop all of this stuff from happening. And he says, he made a speech basically saying that if the government doesn't stop movement towards civil rights, if the government doesn't stop promoting the interests of groups that the Ku Klux Klan doesn't like, the Klan is going to take action. They're going to take revengeance on the government. And Brandenburg argued that they were planning a march months in the future, sometime in the future, in July. They were going to march he was going to get 400,000 people together, and they were going to march into Mississippi and Florida and other places where the civil rights movement was taking place, and they were going to take revengeance on the government, and they were going to take revengeance, armed insurrection against the government in order to stop civil rights from happening. So Brandenburg was arrested and convicted under Ohio's essentially statute against organized crime, because he had said that he was organizing this illegal march. It's generally speaking, you have a right to peaceful protest in the United States, but you don't have the right to violent protest in the United States, and people can be arrested for their actions. Come on. So Brandenburg appealed his conviction, and in 1969, the case came before the United States Supreme Court, and the court sided with Brandenburg. They struck down his conviction, and they said they set a new standard that's different from the clear and present danger test. They said people have a right to express their ideas, and they have a right to say even hateful, hurtful, awful things, and the government can only step in and punish them if what they're advocating is illegal and there's no time to stop that lawless action from happening without the government intervening and arresting the speaker. It's called the Imminent Lawless Action Standard, and it provides people with a whole heck of a lot more freedom of speech than they enjoyed under the clear and present danger test. So this standard is the standard that is used now when the court is asked to rule on whether or not a government action has violated somebody's free speech rights. And we don't, most of the time when people are arrested for protest, it's because the protests have turned violent and they get arrested for an action and not necessarily the speech. That's not always the case. We have seen recently instances of journalists being detained even though they were not involved in any kind of violence, mostly not charged or not held for very long, but there are some people who think that some of the recent actions by the government in response to some of the protests that are happening in America today have gone beyond what the imminent lawless action standard would allow. Of course, other people argue that when protest becomes violent, that is imminent lawless action. And if people are advocating that and the police have no ability to stop it before it happens, then it's appropriate to arrest people. So Brandenburg versus Ohio sets the standard for today for punishing pure speech, the speech that comes out of your mouth or that gets published in a newspaper or a blog or something like that. And I'll give you a recent example of how that's been used really to protect speech, even speech that's scary and even speech that might make people afraid or make people feel personally threatened. It's illegal to send actual threats through the mail or to actually threaten people over like social media and that kind of stuff. People can get arrested for threatening to kill people if there's evidence that they are directing their threats to an individual person and that there's a likelihood that they're planning to carry that out, right? People's right to free speech isn't absolute, but it does come up before the court, and oftentimes the court protects speech that makes people very uncomfortable. And I'll give you just a recent example. Oh, sorry, I got a little definition that I just gave you of imminent lawless action. Punishment is allowed only of imminent lawless action, not advocacy of lawless action. So that is a much different standard than clear and present danger, which allowed people to be punished for advocacy rather than actually plotting and encouraging people, inciting people to lawless action that can't be stopped by the government. The case that I wanted to share with you as a sort of example of how this comes up is a case called Elonis versus the United States, which was decided in 2015, and it involved using the airwaves, in this case the internet, to post what could be regarded as threatening speech toward another person. So Elonis was mad at his ex-wife. She had apparently divorced him. I think she had divorced him and she had taken their kids, and he went to therapy. And one of the things that his therapist suggested was that he write out his frustrations, that he work through his frustrations and his anger in written form. And so he posted this stuff on social media where he essentially threatened to kill his either girlfriend or ex-wife, cut her up into little pieces, and then he said he was going to arm himself and he was going to go find a school to shoot up. And as you can imagine, if you're his spouse, if you're his ex-wife or ex-partner, you're going to be pretty terrified. And so Alonis was arrested and he was convicted for sending true threats through the mail, through the internet. What Alonis argued was that he wasn't actually planning to do any of the things that he was writing about. He was just working through his anger, and that he really had no intent to harm anybody. And so the question before the court was, does the imminent lawless action standard allow enough leeway for the government to punish speech even though there was no intent to harm, if the person it was directed at could reasonably have assumed that it was meant as a true threat? So Alonis argued that it wasn't a true threat. And the prosecuting attorney actually accepted that. They said, we get that. We accept and believe you that you weren't really planning on shooting up a school or killing the mother of your children. But the mother of your children thought you were going to, and that's enough. And the court disagreed. They sided with Alonis, and they said that the only thing that can be punished is an actual threat, a true threat that the person could actually carry out, had a reasonable chance of carrying out. That doesn't mean that the government won't watch you. It doesn't mean that the government won't do an investigation, etc. But they said that the posting of even that kind of vile, those kinds of vile things that he posted on Facebook is protected speech in that context. So I've covered a bunch of stuff in this PowerPoint, but what I wanted to mostly share with you is why we find speech to be important, why it's important in a free society to protect free speech, and how the court has moved over time from a position where the government had a lot of authority to punish people for exposing or expressing ideas that the government found dangerous, to today's standards where even things that the government finds dangerous or threatening are still pretty much protected speech unless the person doing the speaking or doing the publishing is actually trying to incite people to engage in what they call imminent or immediate lawless action. So that's that.